Right, Mr. Smith.
Thank you, my lords and my ladies.
Come up with an answer to the conundrum that you're pondering.
I hope I do. I've got an answer to another question you put to me earlier first, which was the date on which
keep us in suspense then.
The date on which the company's winding up rules came into force, which was the 1st of March 2009. So they came into force the same day on which the 2007 amendments came into force. Now, just before the short adjournment, we were looking at Order 12, Rule 2. So if I can just go back and finish up what I wanted to say about that. It's in Volume 9, behind Divider 9, page 2367. And in our submission, one can ignore Rule 1 for these purposes. One then starts at Rule 2, and Sub-Rule 1 in our submission is a direction given to the liquidator as to when he must exercise the power conferred by Section 112.2. And what's important for these purposes are the conditions stated in B and C, because they include that the NAV must not be binding upon the company and its members by reason of fraud or default. So it's contemplating a situation where the NAVs are already not binding as a matter of general law. So putting it in another way round, it doesn't allow the liquidator to make the NAVs not binding. It doesn't confer a power to override the NAVs. It effectively says that if the NAVs aren't binding, whether that's because of fraud, default, or some other reason that comes under that rubric, then the liquidator shall exercise the power. And in my submission, that's entirely consistent with our submission as to the normal meaning of the rectification jurisdiction. The rectification jurisdiction involves amendments to the documentary record to bring it in line with the true legal position. Now, if you then follow the rule through, what Sub-Rule 2 then deals with is the question of how the register should be rectified if the liquidator is required to exercise the power. So Sub-Rule 1, if you like, is the gateway that gives rise to the direction, and it's Sub-Rule 2 and following that then direct the liquidator as to how the rectification should be carried out. And Sub-Rule 2 says, subject to paragraph 3, he shall determine the true net asset value of the company at each relevant redemption date.
That's probably going to be every redemption date since the company was formed, isn't
Probably,
it?
yes.
Because otherwise you wouldn't deal with the full effect of the fraud.
That's almost certainly right. I mean, on the assumption they're likely to have been monthly subscriptions.
Yeah.
Yes, I agree.
Because the NAV doesn't tell you doesn't just tell you what people redeem at, it tells you what they invest at.
Exactly.
Yeah.
Exactly right. So subparagraph 2 is directed at that. You determine the true net asset value. Paragraph 3 then tells you how you go about determining the true net asset value and the application of accounting principles and so on. Sub-Rule 4 tells you how the register then has to be updated. And then it's only then you get to Sub-Rule 5. And Sub-Rule 5 applies only if the official liquidator thinks it will be impractical or not cost-effective to rectify the company's register of members in accordance with paragraphs 2 and 3. So in other words, in order to get to Sub-Rule 5, you already have to have gone through the subparagraph 1 gateway. You don't get to Sub-Rule 5 unless you're in a world where the NAVs aren't binding upon the company and its members by reason of fraud and default. And I don't know if it was being suggested by my learned friend that Sub-Rule 5 gives rise to some sort of power to override the NAVs where it's considered cost-effective or fair and equitable, but plainly that's not right. You only get there if you're in a world where the NAVs aren't binding anyway.
But the power conferred by paragraph 5 is outside anything that's likely to be in the articles. So the contract between the shareholder and the company will not include the power in paragraph 5 unless it's very exceptional.
Well, that's possibly right, because I think by definition, once you've got there, you're in a situation where the NAVs aren't binding anyway, because you need that to be in sub-rule 1. And then you're in a situation where the NAVs aren't binding and it's not practical to determine the true NAVs, and it's only then you go to sub-rule 5.
Yes, but another example of that is that the liquidator may decide to adopt accounting principles,
Yes.
none are specified in the articles, which are those that appear to him to be appropriate, yes, but not necessarily those which they were entitled to have applied under their terms of a contract with the company.
Yes. But the key point for our submission on this is one only gets into this world if one is through the gateway of sub-rule 1, and one is in a world where the NAVs aren't binding anyway as a matter of general law.
But the answer given to that point was that section 112, subsection 2, doesn't say that you can only operate the power in accordance with the winding up rules.
No, it doesn't. And there may be other examples where the conventional rectification jurisdiction would operate outside of Rule 2, Sub 1. And we deal with this in paragraph 77 of our written case. But one example is simply where the directors have wrongfully refused to register the transfer, and the company has then gone into liquidation. There's been an effective transfer. The directors haven't registered it through negligence or willful default. The liquidator may be perfectly entitled to exercise the section 112 sub 2 power to rectify the register to reflect that transfer. And that's not an example that's given in Order 12 Rule 1, but it's an example of a conventional exercise of the rectification jurisdiction.
But section 112, I'm sorry, I don't take too much time on this. Section 112 is contemplating a different type of rectification. It's talking about a company which has issued redeemable shares at prices based on its net asset value, and then from time to time, and then he has power to settle and, if necessary, rectify the register of members, thereby adjusting the rights of members among themselves. The clear implication of that drafting is surely that he thinks it right to rectify the register because the shares were not properly issued at the prices based on net asset value.
Well, in my submission, no, and that's not what the drafting says. What the drafting says is that in the case of a specific category of company, the liquidator himself has power to rectify the company's register of members. So what the drafting of subsection 2 is doing is identifying a specific category of companies which are in practice investment funds, because those are the companies that issue redeemable shares based on their NAV from time to time. And they're saying, in relation to those category of companies, it's the liquidator, not the court, who's got the power to rectify the register of members. Now, there's nothing in that says, actually, you can only rectify because the NAV has been misstated. He could exercise the section 112 sub 2 rectification power for other conventional rectification reasons. Example I gave a moment ago of a transfer not having been registered because the directors were negligent or simply refused to do it.
But in that case, what's the point of limiting it to cases within subsection 2? I mean, it would be a general application.
Well, all one can say is the legislature has made a decision that in the world prior to 2009, all of these acts had to be carried out by the court, the settlement of the list of contributors and the rectification of the register. They've then said, in relation to the post-2009 period, we're going to change that, so actually the liquidator can carry out the settlement of the list, and in the category of this particular type of company, he can also rectify the register. In relation to other companies, it will still have to be carried out by the court. And one can see that. I mean, it may be considered it's cost-effective or practical for the liquidator to do it. And we know in the UK, our position is that we do take the view that it's cost-effective and practical for the liquidator to do it.
The argument is essentially two-pronged, isn't it? First of all, if the legislature had the intention of enlarging dramatically the power of the scope for rectification, this was the perfect opportunity in which to take it, and
yes,
it conspicuously failed to do so.
Exactly.
And the second submission, as I understand it, is that the gateway in Rule 2.5 only opens when the other gateways have closed.
Yes.
And in any event, as I have understood your submission, cost-effective and fair and equitable must reflect the circumstance that the other gateways didn't open.
Yes.
And that therefore you're dealing with a situation where you have to, not exactly fly by the seat of your pants, but certainly you have to deal with the situation as it presents itself.
Exactly that.
So the connotation to be placed on cost-effective and fair and equitable has to be seen against that background.
Exactly that. But as I say, I mean, our primary point on this is it's really focused on sub-rule 1, because you don't get there until you're in a situation where you can say the NAVs aren't binding for some other reason. And what sub-rule 1 doesn't say is the liquidator can exercise the section 112.2 power to make the NAVs not binding, because that's effectively the appellant's case. They say the liquidator's got this power, which he can basically use to override the contracts of subscription and redemption and rewrite them. But that is plainly not what Rule 2.1 is contemplating. It's contemplating a situation where those contracts are already liable to be vitiated because of some sort of fraud or something, and then the liquidator can act.
Well, I think we have that point.
Yes,
Let's
sorry to labour it. And so just the other point just to make on this, it was a point that was made in argument this morning, is that it is telling Order 12 doesn't anywhere deal with the situation where the NAVs are binding. Because if it had been the intention for the rule to apply in those circumstances, why wouldn't it have set out the accounting principles applicable in that sort of scenario? Strongly suggests that wasn't the intention.
Mr. Smith, it's said against you that although 112 sub 2 uses the word rectify, which
yes.
you say picks up a well-understood meaning, the whole phrase is rectify ... thereby adjusting the rights of members amongst themselves.
Yes.
How do you, in your analysis, give effect to that part of the description of what this power is?
Well, the phrase adjust the rights of members between itself is another, if you like, stock phrase of company law. I mean, I perhaps should have taken you to this morning, because we put this in the bundle for these purposes as well. If you go back to divider 22 of bundle 9, section 102 of the 1862 Act, and this is the provision that's reflected in subsequent companies legislation.
Page number?
It's 2410.
Thank you.
So there's always been a power in the company's legislation for calls to be made on members in respect of partly paid shares. And the phrase for the adjustment of the rights of contributors among themselves appears in that context. So what the legislation contemplates is that by making calls on shares, you can adjust the rights of contributors between themselves in terms of their, effectively, their economic participation in the winding up. Now, you're not actually changing their rights, but you're adjusting their ability to participate in the winding up in economic terms. And that, the phrase adjustment of the rights of the contributors amongst themselves in our submission simply reflects the consequence of carrying out that exercise. Likewise, in section 112.2, if you rectify...
Does that carry through into the modern legislation?
It does, yes. We can dig out the reference to that. Yes, it does. And that's basically the stock phrase. And we've given, I think, in our written case, just bear with me, excuse me. I think we deal with this point in our written case. Yes, there's an authority called Shields, which deals with this point. Perhaps we'll dig out the reference. But it basically explains that what that does is adjust the rights of the members between themselves as a consequence of making the calls on them in respect to the party paid shares. And in our submission, the same phrase in 112.2 reflects the consequence of carrying out the rectification exercise, because if you do rectify the register, that does necessarily adjust the rights of the members between themselves.
Is that because otherwise the unrectified register would be conclusive as to their rights?
Yes, exactly.
I think section 49 deals with that, but in a slightly watered down way. It
Yes,
talks about
I'm
it
not
being
sure
prima facie evidence rather than conclusive.
Yes, I'm not sure it's 49.
It may be,
That's
it's
the-
just after 46 anyway.
Yes.
Thought it was.
Yes, it's 48. You're
48,
quite right.
sorry.
Yes, you're quite
Yes.
right. It's, 49, I think, deals with liability of members. Yes, 48, the register of members shall be prima facie evidence of any matters by this law directed
Yeah.
or authorised to be asserted therein.
But can you point us to any precedent for the expression adjusting the rights of members between themselves?
Yes. Well, I'll come. We do deal with this in our written case.
I'm not sure there is a precedent, is there?
Well, let me.
It's a smaller group than the contributories,
Yes.
because it's just the existing members.
Yes, I think let's look, if we can go first to Birch and Cropper, Volume 9, tab 28, 3196.
I was simply asking whether there was an expression in the statute.
In the statute,
Is there any other time when the legislature has used this phrase?
yes, I believe it's been used in relation to the power to make calls on contributories, which is now in section 154 of the Insolvency Act 1986. So if you can go to volume 9, tab 16, 2397.
But that's adjusting the rights of contributories
It is,
among
but
themselves,
that's where
not members.
Quite, but that's where the phrase comes
Well,
from.
except that the legislature has deliberately, in section 112, limited the class to members.
Yes, but the phrase adjust the rights between themselves, I mean, it derives from what was a section 102 of the 1862 Act. You can now see it in section 154 of the 86 Act.
I suppose you would say that they use members here because if what's happened is an adjustment
Yes.
or a rectification of a share register, which has got nothing in this context to do with making calls,
Yeah.
then it will be the members who are affected by it.
Exactly, and not a contributory who is capable of being a former member.
Because he won't be on the share register.
Exactly.
I think as well as that, Professor Benyon says that where a phrase is used in different contexts in legislation, it should conventionally be given the same meaning.
Yes,
So whether it's contributories or members, you would say matters not. Adjusting the rights of members, to give that an enlarged interpretation over adjusting the rights of contributors
exactly.
would be, how shall I put it, unconventional.
Yes.
You may wish to make a call on a former member if he's on the B list.
Sorry?
You may wish to make a call in a liquidation on a former member
Exactly.
on the B list,
Exactly.
who is not now a member.
Quite a
and
former
not in
member.
the register of members.
Because he's liable to contribute.
Is liable to pay calls in a liquidation.
Yes.
So it wouldn't be covered by adjusting the rights of members.
No, that situation wouldn't be apposite for adjusting the rights of members in the particular situation.
No.
My lady instances.
Yes, and can I just give you just the examples in the case law where they've discussed the phrase adjusting the rights among themselves. And the first real discussion of this is in a case called Birch and Cropper. It's a decision of the House of Lords. Volume
I think we've got 3196. Is that right?
Yes,
A case
that's,
called Leon Moore's case.
No, the case, I was going to a
Well,
case called,
simply I noticed that it has the phrase adjust the rights of the members amongst themselves, which
Yes, that may be. Yes, that's the second one I was going to.
I see.
That's Shields Maritime Insurance Company, but you're quite right. So, I mean, let's go to them in order. There's Birch and Cropper, first of all, which is 9/282536. And it's beginning at the top of page 545. They're discussing the question of distribution in the winding up of the Bridgewater Navigation Company Limited in that case. Now, in the case of members of a company limited by shares, what are their rights and interests in the company in the absence of any special regulation, and what are the rights of the contributories amongst themselves which have to be adjusted in the winding up? And then he basically goes on to say that amongst the rights to be adjusted, the most important are those which arise when there is a difference between shareholders in the amount of calls paid in respect of their shares. And then just picking it up about halfway down the page, the rights arising from unequal contributions on shares of equal amounts must be adjusted, and the property of the company, including its uncalled capital not required to satisfy prior claims, must be applied for that purpose. But when those rights are adjusted, when the capital is equalised, when equity founded on equality of contribution, what equity founded on equality of contribution could possibly be made? So the adjustment of the rights of members is effectively a consequence of making the calls in respect of the unpaid shares, and reflects, in our submission, effectively the consequence of carrying out that exercise. The other case on this is Shields Maritime, which is volume 12, tab 56, 3196. Which I think is the passage my Lord Carnworth had.
Yes.
And again, it makes basically the same point, 2/3 of the way down. Exactly in the same manner, in a company of limited liability, where there are many shares, some of which are paid up and the rest not paid up, the persons who have paid up in full are not required to be on the list of contributories. But as soon as it is found there are assets more than sufficient to pay all the debts, then calls may still be made on the persons who have not paid up in full in order to adjust the rights of the shareholders between themselves. So it's describing the process or the consequence of making the calls on contributories. And I can also just give you the references, perhaps rather than turn them up, but we also included the relevant extracts from Macpherson on this point.
On that one, I was just looking for the provision which talks about adjusting rights of members among themselves. Is that? They got 3194 possibly. Seems to be section 201.
Yes.
We need some for the adjustment, yes. The members among themselves.
Yeah, so this is under the 1862 Act, and
That's section
200.
Section 1.
I think that's set out at the bottom of the page in the footnote, is it not? On
Yes.
194.
It wasn't a registered company.
Well, that explains why we're looking at a different section potentially. But it's the same. It's the same jurisdiction in the sense that one's got the ability to call on the contributory. And just in terms of the textbooks, we've got Macpherson at tab 76, 3463. And which deals with this point.
Sorry, page.
It's 3463.
Thank you.
And it picks up this language about sort of 8 lines in. and talking about the power to make calls, the power of the liquidator to do so is limited to the purposes specified in the Act for the payment of any money which is necessary to satisfy the debts and liabilities of a company, to go the expense of winding up, and for the adjustment of the rights of the contributories among themselves. And then they go on actually over the page, at the top of the next page. Even where the company is solvent and able to discharge its debts in full, the liquidator is entitled and indeed bound to make calls for the purpose of adjusting the rights of the contributories inter se. And then they set out an extract from the Shields case, which we were just looking at.
Yes.
And then, just for your note, there's a further treatment of this on page 3467, where Macpherson describes how the process of making the calls on the contributories should be made.
So if the company is insolvent, do you make the contributors pay up in cash to enable the creditors to be paid?
Yes.
If there's a surplus, you don't need to call on the contributors in that sense. But nonetheless, the fact that some contributors have paid in full and others haven't means you have to make an adjustment before you distribute the surplus to the contributors stroke members.
Exactly right. And the page 3467 of Macpherson describes how you carry that process out. And in practice, the liquidator will try to do it without making cash calls on the members.
Yes.
But he may have to ultimately make cash calls. It depends on the level of assets in the liquidation and the extent to which shares are fully paid or partly paid. But what we'd say is it's clear that the phrase adjust the rights among themselves isn't intended to confer some sort of substantive jurisdiction on a liquidator to alter the rights attaching to shares. It reflects the consequence of making the calls on the shares. And we say the same phrase must have exactly the same meaning in section 112.2. And for your note, it's the reference I was struggling for earlier is paragraph 86 of our written case, where we deal with this point.
In section 112.2, the liquidator is to do this if necessary.
Yes.
If necessary isn't further explained.
Yes.
So if necessary in order to what?
Well, we would say to reflect the underlying legal position, so the underlying legal rights. So, I mean, this goes back to what we say the fundamental concept of rectification is. It's to have a documentary record which accurately reflects the legal position. So if there is a mismatch between the two, because the legal position is that Mr. X is the shareholder, but it's shown on the register that it's actually Mr. Y, then it's necessary to correct the register to reflect that.
Whereas the contrary argument is if it's necessary to do justice.
Yes. If necessary to do what the liquidator thinks is just, basically.
Necessary to reflect true net asset values where fictitious asset values were in fact employed to calculate the number of shares in issue.
Well, and when you say fictitious net asset value, I mean, these were net asset values that were valid and binding. They're valid and binding under the articles. It's accepted. That's the position. It's accepted the contracts of redemption and subscription are valid and binding. I mean, and one of the points we're going to come to is that the mere fact that a NAV may be infected by a fraud in one of a fund's investments, it would be very strange in our submission if that led to the reopening of NAVs generally. And Primeo, Hevel's NAV was not fictitious in the sense it was computed and calculated in good faith by the directors in accordance with the articles on the basis of information provided by Bilmith. And that's not suggested otherwise. Now, I think that then takes me to the question of just to summarise the question on construction, and we've obviously covered a lot of ground on this already, and perhaps if we can go back to section 112 yet again, back in volume 9 at page 2361. Now, as you know, the key issue in our submission is the meaning of the word rectify in subsection 2. That's the word that effectively confers the power, and that's really the operative word in the section. And our submission is it bears the meaning which is always borne. Importantly, it bears the meaning which it bears in other sections of the same Act, specifically section 46, and it simply allows the register to be amended to reflect the true legal position. Now, against that, in our submission, the appellant's construction is not borne out by the language of the section or any of the other admissible material. The first point we'd make is that the appellant's construction involves the court accepting the proposition that the draftsman intended to effect a fundamental change in the Section 112 jurisdiction as between the 2007 law and the 2009 law, but that he nonetheless used exactly the same language of rectification. Because if you'll recall, in the existing 2007 law, that contained a rectification power, and I think it's common ground, it can't really be suggested otherwise, that in that context, rectification bore its conventional established meaning. But the appellant's case involves you accepting the proposition that the draftsman intended in the 2009 revision to introduce an entirely different, far-reaching substantive power, but that he used exactly the same language. Well, he used exactly the same concept. So there's this, what we would say is ultimately an untenable point, that their case depends on there being a fundamental change in the law between the 2007 and 2009 piece of legislation, but that exactly the same language has been used. And that, we would suggest, doesn't.
I think perhaps we have that point.
Yes.
Your point is that it's not only incongruous, but it's unheralded.
Indeed.
Right. Well,
so
let's move on then.
That's the first point. You've got the second point, which is important, which is their case involves attaching different meanings to the concept in section 46 and 259 verses 112. As a matter of ordinary language, I think we would accept that at a stretch you could say rectify is capable of encompassing rectification by reference to standards of justice. But we do suggest it's more redolent of an exercise of correcting a documentary record in order to reflect the underlying legal position.
Do you get some help from the fact that the full phrase is not just rectify, it's settle and, if necessary, rectify?
Yes.
Settle presumably where the register is incomplete, where there's been some management failure and the thing just hasn't been kept up to date.
Yes.
And rectify where it purports to be complete, but it's just wrong.
Yes. Yes. Well, you can see it's it's certainly part of a composite exercise as part of the winding up machinery that the liquidator needs to go through to have a register of members, primarily in this case to enable him to carry out the distribution. And ultimately we obviously accept that as a matter of legislation, the legislature could confer a power on a liquidator to override contractual and proprietary rights. As a matter of legislative authority, clearly a legislative body could do that, but we do submit it would require very clear language, because that would be a far-reaching step, and you don't find that clear language here. On the contrary, you find language which bears an established historical meaning, which is entirely consistent with that notion. So we do, for those reasons, submit that their construction doesn't get off the ground, really. There's some other points we would then make, really in relation to the consequences of what we say their case is. We do submit it would be remarkable for a power of this nature to be vested in a liquidator. Because if the appellant is right, then this is a jurisdiction to vary and override established property rights, which are valid and binding as a matter of contract law, as a matter of property law. The sums involved are likely to be very substantial, given the nature of investment funds. And on the appellant's case, all of this is to be done by reference to what is considered to be just in all the circumstances by the liquidator. And we do suggest that it would be somewhat odd to confer a power of that nature on a court, but it would be somewhat odder still to confer it on a liquidator, who is, albeit an officer of the court, a private individual, is to confer on him an extraordinary power to be exercised by reference really ultimately to his own perception of what justice requires in any given case. And we submit that would be very odd.
It's probably a virtually limitless power, isn't it, if the appellant is right?
Yes.
And there's no clarification as to what is meant to be, what falls within the scope of what is just and equitable.
Yes.
And one can envisage a very wide-ranging inquiry would have to be made in order to come up with a conclusion of what is just and equitable. Well, on the other hand, of course, it's the daily diet of courts, I suppose.
I mean, we agree. And the other point you can make, just by way of comparison, is look at the other examples where courts have conferred jurisdictions and powers to override contractual and proprietary rights, such as those in relation to shares. You've got the example, most obviously, of a scheme of arrangement, Section 84 of the Companies Law. That is hedged around with a number of safeguards. You have to go to court twice. You have to have meetings of shareholders in the relevant classes. They have to approve it by the requisite majorities. It's only if you skip through all of those hurdles at great cost and expense and involving quite a lot of time as well, that you're in a position where the contractual or proprietary rights can be varied. Now, if that's the way in which these contractual and proprietary rights are protected in relation to schemes, it's somewhat incongruous just to give a liquidator a very open-ended power just to vary and override those rights as he deems just. I mean, the other point we would make as well is regarding the circumstances in which on the appellant's case, the power under Section 112.2 to restate the shareholdings in an investment fund would arise. Now, in this context, it has to be borne in mind that the present case is an extreme and unusual one, in that 100% of Herald's assets were invested in Bilmis. In practice, it's likely that there will be many examples where an investment fund has invested in a range of different investments. I mean, in fact, it would be rather unusual to have an investment fund that simply invests in one investment. You would expect, in the normal way, an investment fund to have a diversified range of investments. Now, that gives rise to a very difficult question on the appellant's case as to what degree of fraud in relation to those external investments is required in order for the power which he says exists under Section 112.2 to rewrite the shareholdings to arise. Now, the example we give in our written case is one where an investment which amounted to, say, 10% of the fund's last reported NAV turned out to be fraudulent. So it's made a fraudulent investment, and that accounts for 10% of the net asset value. Question one asks rhetorically, is that sufficient to engage the Section 112 power? Is 10% sufficient? Does it have to be something more than that? Does it have to be 25%? If so, why? All of these questions to which there aren't answers start to arise. And this is the difficulty of developing any sort of power which seeks to override legal or proprietary rights.
But could I just try another point there, just seeing this from a slightly different angle? If a person subscribes for shares on the basis that they produce an asset worth £100 and they get given £101 shares, and then the company goes into liquidation and the liquidator discovers that the asset was only worth £1, he would be able to make a call for the £99, wouldn't he?
Well, not in this case, because, I mean,
I'm taking my example. Just
well, I mean, it depends on the contract, doesn't it, of subscription.
Well,
so.
we're talking about, there's no question of a certificate of value binding or anything like that. You simply transfer an asset which is said to be worth £100, and you get given 100 £1 shares, and then the liquidator says that asset is only worth £1, always was worth only £1.
Isn't that the classic example where the subscribing shareholder could rescind the contract of subscription for misrepresentation
Well,
on the
not
basis?
once the company's gone into liquidation. I think that might prevent him doing that. Loss of right to rescind. So let's suppose, just bear with me for a moment, supposing that is so, and the liquidator is entitled to say these shares, 100 shares issued fully paid, are actually only paid as to £1 each, 1 penny each. He would then make a call.
Yes.
Right. Now, if you take that to a situation of an investment fund, a mutual fund, where there are lots of consumers.
Yes.
And small investors and vulnerable investors.
Yes.
Supposing that they didn't know it, but their shares were issued at a price which was not going to result in a fully paid share, you wouldn't want, if you were the legislature, to have the liquidator making calls.
Yes.
And therefore, you might give the liquidator the power to adjust the rights between the members to eliminate that possibility.
Yes, but I don't believe I've ever seen an investment fund issue partly paid shares. I mean, I'll be corrected if I'm wrong, but the investment fund doesn't issue partly paid shares. What happens, as you know, is they produce the monthly NAV, which is certified. That then effectively becomes binding as part of the contract of subscription, and fully paid shares are issued in return for the price as determined by the NAV. So
I can appreciate it. You would say it's a rare case, but if it were such a case, it is open, is it not, to a legislature to say, well, the better scheme would be to have the liquidator adjust the rights between themselves and therefore eliminate the liability for those calls.
Yes, I mean, I think my answer to that is just, so far as I'm aware, and those behind me, correct me if they have any different knowledge, investment funds don't issue partly paid shares, so it's not a feature of the sort of companies that appear within the world of Section 112, subsection 2. So, I mean, there's no reason for them to issue partly paid shares, because the whole mechanic is based on this sequence of monthly NAVs. So you simply determine the price at the end of each month, and the subscription and redemptions go through mechanically at that price.
But let's suppose that I don't know, I haven't looked at the details here, but if the investor was investing £100 and giving it to an agent to subscribe for Madoff funds units, which were then given to Herald in exchange for Herald issuing shares, you could well have had an inflated allotment by Herald.
Well, yes, I mean, this is the reality of the situation. If the NAV is binding...
Well, I'm taking an example where it isn't binding.
Well, if the NAV isn't binding, well, one is in a completely different world then, because obviously one is then within the 112.2 and Rule 2.1 power, if the NAV isn't binding.
So you could adjust rights in that situation.
If as a matter of general law, for some other reason, the NAV isn't binding because there's been an internal fraud in relation to the fund, absolutely. But I think we're dealing with a situation in this case where the NAVs are binding, there's been no internal fraud, and the only fraud is in relation to one of the investments the fund has made. And that's a different situation. And the point I was just making is that if the appellant's right that you can exercise this Section 112.2 jurisdiction merely because one of the fund's investments has been fraudulent or turns out to be fraudulent, where do you draw the line? But
why should the line even be drawn below the existence of some fraud? Because the section is entirely silent about what might be the underlying motor.
Yeah.
It doesn't say fraud. Of course the rules do, but we're trying just to look at this at the moment, as I understand it, without getting too hung up about the rules.
Yes. No, absolutely. So you're right. So you could, I mean, on the appellant's case, it could be sufficient that, say, an investment amounting to 1% of the fund's assets turns out to be fraudulent. And then on his analysis, that leads to the unravelling of the whole thing, and one can rectify the register and effectively redo everything. But as I say, I mean, there's no guidance in the legislation, and there's no answer really given to these questions about where one would draw the lines. And then the final point, just on construction, is that there is a further reason in our submission why it's unlikely the Cayman legislature envisaged Section 112(2) as allowing the rewriting of shareholdings in an investment fund and in circumstances such as the present. And that's this. The policy reason, which it said justifies that step, is the perceived injustice which might arise where an investment fund invests in something that turns out to be a Ponzi scheme, and certain investors benefit from what can be seen with hindsight to be fictitious profit. So that's the policy reason that's put forward by the appellant as justifying the existence of that sort of power. But the principal beneficiaries of that sort of situation are those investors who've redeemed their investments. They are the principal winners. They're the ones who really do well out of this. It's the people who've redeemed entirely and gone off into the sunset. Now, if the policy goal of the legislature had been to deal with that perceived injustice, why didn't it include some provision within Section 112 or the rules or elsewhere in the legislation which enabled the reversal of those redemptions? That is the prime example of someone who's benefited from fictitious profit, but yet there's nothing in the legislation, as my friend accepted, to enable the recovery of that. So we do say if the intention of the legislation had been to enable shareholdings in a fund to be rewritten simply to reverse the effect of fictitious profit, why did the legislature only do half the job or less than half the job by not including an ability to claw back from those investors who'd got out completely? And that, we submit, strongly suggests it wasn't the intention of the legislature, because they could have done that, and a sensible, coherent approach to the legislation would have included the recovery of those sorts of...
And is the reason for the concession that it didn't do that because it talks about only adjusting the rights of members amongst themselves?
Yes.
One might, I suppose, approach it and say, well, they could rectify the register of members by putting back on the register someone who had redeemed in full, cancelling the debt and asking for the money to come back, please, and leaving him as an unredeemed member, and then adjust his rights as somebody who's now on the register of shareholders as against everybody else.
Well,
but that's not being advanced, as I understand it.
That's never been suggested. And the difficulty, one possible difficulty with that would be that the person in that position would no doubt say that they're a former member.
Yes.
And therefore you can't extend the rectification jurisdiction to them because it only applies to members.
Well, I assume that was the reason, yeah.
But you're right, but I have a more general point is just what does it tell us? The fact that those powers aren't there, what does it tell us? And it tells us that what the appellant suggests is unlikely actually to have been the policy goal of all of this. We've made some points about certainty and finality, about external and internal fraud. Those are all in our written case. I'm not intending to go over those. I was going to then just address briefly the question of the proposed distribution methodologies. Now, this obviously only arises if we're wrong on the construction of Section 112(2). On this point, at first instance, the appellant proposed a distribution methodology called rising tide. On appeal to the Court of Appeal and before this court, he proposes a different method called net investment method. And as you know, both of those distribution methodologies are borrowed from the United States, where they're sometimes used in insolvencies of brokers. Now, we've explained in our written case how they work, and you've seen SEC and Huber. We don't need to go over that. 3 points which we'd make. The first point is just to note that the US courts would not in fact apply either method in a case such as the present, where the fund itself was not a Ponzi scheme. The net investment method was applied in the case of Bill Miss itself, because that was a Ponzi scheme, as you know. But in other cases, where the fund itself is not a Ponzi scheme, then what is called the last statement method applies. So in other words, the customer is allowed to claim for what's shown on his last statement as the balance showing on his customer account. And we've referred in our written case to a case called Beacon Associates, which is in volume 9, behind divider 27. Page 2499. It's a decision of the United States District Court, and it's interesting because it's an example of a feeder fund into Bill Miss, so a fund that's analogous to Herald in the present case. And if you go to 2500, midway down the right-hand column, under the heading Beacon's Madoff Investments, you can see it says that since its inception in 1995, Beacon invested approximately 70% of its assets with Bill Miss. So slightly lower percentage than the present case, but still substantial. And the argument in that case was whether something called the valuation method should apply, or something called the restatement method. And you see those described at 2501 in the left-hand column. Second main paragraph down, the first such method, referred to as the valuation method, treats the Madoff losses simply as though they occurred due to market fluctuations. So you treat them simply in the same way as if the share price of the investment had gone down. But the alternative method, which was something called the restatement method, basically treated the losses as having occurred immediately at the same time as the investment into Bill Miss was made. And as they say at the bottom of the left-hand column, that had the effect that all profits made from the Madoff investments would be eliminated, and each member's capital account balance recalculated to reflect the historical losses. So that was effectively a method of stripping out the fictitious profit. But you'll see what the district court said at 2507 in the left-hand column under heading C. The cases employing the net investment method of distribution are inapplicable because Beacon itself was not a Ponzi scheme. And in the first paragraph towards the end, there's reference to Judge Liffland's opinion in Bill Miss. But then the district court go on to say, although it may well be true, as Judge Liffland reasonably articulated, that in Ponzi scheme cases, equity and practicality favour the net investment method, the present case is distinguishable because Beacon itself was not a Ponzi scheme. And then over on the next page, he goes on to give his second and more important reason. Secondly, and more importantly, whereas Bill Miss was subject to the Securities Investor Protection Act requiring that customers share pro rata in customer property to the extent of their net equities, Beacon is governed by its operating agreement, which requires that Beacon's assets be distributed in accordance with the valuation method. The court is not aware of any legal authority that would allow it to upset this contract between and among Beacon's members, and is unpersuaded that equity demands it. So the 2 points arise out of that. First, there is a certain irony in that the appellant is seeking to apply a distribution methodology borrowed from the United States and seeking to apply it in circumstances where it wouldn't, in fact, be applied in the United States. But the second point is it's interesting to observe that the US courts adopt what we say is the correct approach and the actual approach of the Cayman courts, which is that where an investment fund is not itself a fraudulent Ponzi scheme, and there's no reason to set aside its constitutional documents as a matter of applicable law, as a matter of general law, then you give effect to them. Now, the second point is that we also submit that neither the net investment method nor the rising tide method can properly be said to involve rectification of the share register. Again, this involves to some extent what we said about the true meaning of rectification, but it's important to observe that neither method really involves an attempt to work out a true share register by calculating the true NAVs and substituting those for the NAVs by reference to which the shares were in fact issued and redeemed. Neither method is really geared at working out what a genuine share register would say. And indeed, the share register is actually completely irrelevant to both methods of distribution. Both methods of distribution are simply based on cash accounting, adding up what was paid in, subtracting what was paid out, which gives you a net claim. But the share register is actually completely irrelevant to that process. It could as well be carried out by a ledger. So in that sense, we suggest that neither method really, in any recognisable sense, involves rectification of the share register. And the third point is that we don't accept that the net investment method is in any case the, quote, fairest, unquote, method of distribution. Now, the appellant asserts that it's unfair for investors to be able to rely on the shareholdings recorded on Herald's share register because they reflect what are now known to be fictitious profits reported by Bilmis. But equally, investors would have received customer statements at the time and would no doubt have relied on those statements for the purposes of their financial planning, possibly for paying taxes as well. If they'd read the articles and the offering memorandum, they'd have understood that the NAVs and the contracts of redemption and subscription were binding. And it's not immediately obvious to us that it is self-evidently fair now to change the basis on which investors may have acted and organised their affairs. The other point is that it's also far from clear that the net investment method is itself a perfect method of distribution, as the appellant himself has previously accepted. If you can go to volume 3, behind divider 21, just to show you very quickly what was said in there about this. Page 773. And this is the skeleton argument of the additional liquidator for one of the hearings before Mr. Justice Jones, where he considered this issue. In paragraph 203, he says the net investment method is fairer than the last statement method, and that indeed has been his position throughout. But as he accepts, I mean, it's far from perfect distribution method itself, because in the case of someone who remains a member, it doesn't make any attempt to deal with the redemptions which that member has made. So as he said in the penultimate sentence, if you have an investor who'd redeemed 90% of the capital pre-liquidation, they'd be entitled effectively to the same rateable share in the same way as an investor who'd redeemed 10% or nothing at all.
And that's what the rising tide method would deal with.
Exactly.
Yeah.
So that's why, at first instance, the additional liquidator was positively arguing for the rising tide. The difficulty with that is it involves you waiting until all the distributions have come in before you can apply the methodology. But the point I would make is it's not self-evident that the net investment method is itself a paradigm fairness. The final issue then, very briefly, concerns the in-specie subscription made by Primeo for shares in Herald in May 2007. That subscription took place as part of a reorganisation of Primeo's investment with Bilmis. And basically what happened was that prior to that date, Primeo had a direct investment with Bilmis. It had its own customer account with Bilmis. And that was then reorganised so that Primeo's investment was then held indirectly through Herald. And as a matter of mechanics, the switch was implemented by transferring the rights in respect of Primeo's customer account with Bill Miss to Herald in return for Primeo being issued with shares in Herald by reference to the value of that account. So that was really, as a matter of mechanics, how it was done. It could as well have been done by a cash redemption and cash reinvestment at the time. There's no reason why it couldn't have been done in that way, and no doubt the reason it was done without the cash redemption and reinvestment was simply as a matter of convenience, that they'd simply short-circuit it by assigning the value of the customer account over and subscribing shares. Now, there's no doubt that that subscription remains binding as a matter of law, and the appellant's attempts to void the subscription on grounds of mistake were rejected by the Grand Court and haven't been appealed. He says, nonetheless, the subscription should be reduced to reflect the net investment which had been made by Primeo into Bill Miss at the time of the subscription. Now, as we understand it, his arguments on that rest entirely on his arguments in relation to the proper construction and effect of section 112.2 and the application of the net investment methodology. And if those arguments are rejected, as we submit they should be, then the arguments in relation to the in-specie subscription simply fall away. And my learned friend accepted quite rightly that there's no basis for challenging the adequacy of the consideration or anything like that. But there is, in addition, a further point which we say arises in relation to the Primeo in-specie subscription. Assume, for the sake of argument, that the appellant is right, that he's able to use 112.2 to override and vary the contractual and proprietary shareholder rights, and that he's able to apply the net investment method of distribution. The question that then arises is, how do you apply that methodology in relation to the Primeo in-specie subscription? Now, on the face of it, the application of the methodology makes little sense, because Primeo didn't invest any cash at all with Herald as part of this subscription. The whole point of the subscription was that no cash would be invested with Herald. But it's well established that a subscription for shares may be made for non-cash consideration. There's a line of authority from the late 19th century, beginning with a case called Re-Rag, which establishes that. And Herald's articles of association, in the present case, allowed for a subscription for shares to be paid by non-cash consideration. And if I could just ask you to turn up volume 1, behind divider 8, at page 68. In the middle of page 68, there's Article 16(3)(f) of Herald's Articles of Association. The company may, but shall not be obliged to accept payment for participating non-voting shares other than in cash by way of a transfer to it of assets and securities, collectively acceptable securities, upon such terms and conditions as the directors in their discretion may from time to time determine. Now, Mr. Justice Jones held that there was such a determination at the time, and that the directors carried out the relevant valuation of the acceptable securities. And that's paragraph 116 of our written case, and his February 2016 judgment, paragraphs 24 and 29, pages 596 and 597 of the bundle. Now, there's no basis for going behind the adequacy of the consideration. And in our submission, in light of the provisions of the articles, that is to be treated in exactly the same way as if it had been a cash subscription for the same amount. That's the purpose of these provisions of the articles. They say you can accept consideration for the issue of shares other than cash. And if the directors determine that, and they carry out the relevant valuation, as Mr. Justice Jones said they did, then that's binding. And in our submission, that has to be treated as if it was the relevant cash consideration by Primeo into Herald. And that isn't, I would suggest, a technical submission, because as I said a few moments ago, there's no reason why this particular transaction couldn't have been carried out by a cash redemption and reinvestment at the time, and the only reason it wasn't was no doubt for convenience. So that is a further point that we say effectively precludes any attack on the in-specie subscription, even if we're wrong on everything else. And your Lordships will have noted that both before Mr Justice Jones at first instance and the Court of Appeal, the attempt to attack the in-specie subscription was emphatically rejected by both courts. If you just bear with me. Unless your Lordships and Ladyships have any questions for me, those are our submissions.
Spot on time, Mr. Smith. Mr. Alata? No. Mr. Again.
My Lords, my Ladies, I'm not going to go over points which I've already gone over, but just one point, if I might, in relation to the report, which has been looked at in some detail. That is the report of the Companies Law, the Cayman Island Law Commission report. In our respectful submission, one can't place too much weight on the report when one comes to look at the words of section 102.2. The report plainly doesn't cover everything, and it plainly is incomplete in the sense that it doesn't deal with 102 subsection 2 in its focus on solvent liquidations of funds, because that is a new provision. and it's simply not there. But we do know that Mr. Justice Jones was a member of the committee, and we also know that he was a member of the Insolvency Rules Committee. And if I can ask your Ladyships and your Lordships to look at page 1181, which is, I think, in bundle 4, at tab 22. Sorry, it's bundle 3 at tab 22. No, I'm sorry. You bear with me just for a moment. It's tab 24. It's bundle 4, tab 24, and the passage at 1181 is the judgment. And I was going to ask the court to turn to paragraph 22. And this is what Mr. Justice Jones said. He said that 112.1 and 113 have their genesis in the 1862 Act because they continue to deal with settling a list of contributories and making calls against contributories. However, Section 102.2 and Winding Up Rules Order 12 Rule 2 are entirely new provisions specifically aimed at dealing with issues which can arise in connection with open-ended mutual funds, which collapse and are consequently put into compulsory liquidation. So that passage, in our respectful submission, does carry weight. It was picked up by the Court of Appeal, and it reflects the wording of 112.2 that we have looked at. 112.2, we know, uses some familiar language, but it uses familiar language in the entirely new but limited context of solvent liquidations of investment funds, which have issued shares at NAVs from time to time. And in our respectful submission, 112.2 is the first time that one sees in the legislation, having reviewed it to this point, the combination of settling the list, rectifying if necessary, and thereby adjusting the rights of the members as amongst themselves. And that, in our respectful submission, has to be seen as distinct from the exercise which would be carried out in relation to calls on contributories, because that has been dealt with already in 112.1. And so we've got tab 9 at, bundle 9 at tab 6 at page 2361. 112.1 has dealt with the question of adjusting the rights of contributors in relation to the settlement of the list and in relation to the question of calls. And in 112.2, one's moving a gear completely into a different context. And in that context, the liquidator has a power to settle, and settle is a word capable of wide meaning, and, if necessary, rectify the company's register of members. And here we're dealing with the register rather than the list of contributors, thereby adjusting the rights of members amongst themselves. And we saw from the authorities the wording which is used is adjusting the rights of contributors amongst themselves, except in the case that we saw in relation to the unregistered company, which, as I understand, it wouldn't have had shareholders. And so one's dealing with a different structure at that stage. So 1122 does, in our respectful submission, break new ground. And the indications that that is a well-founded submission are, firstly, the limited context in which it operates, and it is a limited context in which it operates, and the fact that at the same time as Order 12, as 112 subsection 2 came into effect, the winding up rules themselves came into effect. And your Lordships and your Ladyship have the points which I've made in relation to Order 12, Rule 2.
I think, of course, the observations of Mr. Justice Jones in paragraph 22 have to be read in the light of his decision as to whether the section 102.2 power should be exercised in paragraphs 23 and onwards.
Well, Mr. Justice Jones was clearly of the view in his judgment that the power should be exercised in this case. And in his...
He agreed with Mr. Smith that it's inherently improbable that the legislature intended to confer upon an official liquidator a power to interfere. I'm just reading from the top of page 1193.
So 1193.
Yeah, it's about...
But what Mr. Justice Jones determined in that case was that the register should be rectified. What he didn't care for was the net investment method. And in fact, his proposal, his method of rectification, as proposed, was to draw up a register on each date and substitute for the NAV $1,000 a share. So effectively, shares were issued on the basis of 1 for 1. Mm-hmm. And that will reproduce, ultimately, the same result as the net investment method.
Right.
Mr. Justice Jones took the view that if you used that method, because you had to, that method excluded the scope of any rectification to the rectification of the register except for the in-specie subscription. So he took the view that the way his judgment worked was, well, if you could use net investment, then you could rectify the in-specie subscription. But he didn't think that the net investment, so that's paragraph 32, where he said at 1197, if it were possible to employ either of the net investment or rising tide distribution methodologies, the validity of the Primeo in-specie subscription would be irrelevant. So essentially he was saying, well, the liquidator is right about the power and how it can be exercised, then you could rectify both the register throughout and in relation to the in-specie subscription. But that was not the method which he was prepared to countenance. But his view was that there was a power, it could override the contractual rights upon which shareholders had subscribed. And in paragraph 25 he said, in my view there could be no clearer case in which the power ought to be exercised. Yeah. So it was really at the calculation or the rectification methodology that he parted company with the additional liquidator, but he was absolutely clear as to what the extent of the 112.2 power was. It just did not go as far.
He may have been making that giving that sentence my Lord has read as the reason for his next sentence, i.e. you couldn't rectify the register against a former shareholder.
Yes.
So you can't disturb the fact that there is a given class who have all the proprietary rights.
No.
You can adjust between them.
Yes. Yes.
It did occur to me while I'm just speaking that the proposal for section 112.2 could have come from the regulator of open-ended investment companies, the Cayman Islands Monetary Authority.
Well, obviously a number of...
Haven't got that material.
We don't have that. And of course, what we do know from the report is that there were a number of committees all feeding into the exercise. And one knows that that's a huge amount of work to be doing. They were making fairly radical changes to parts of the company's legislation to bring it up to date. And in our respectful submission, they were also making a radical change in this context, but in relation to a subset of companies which would have limited application. But what one can't say is that the report in relation to 112.2 is complete, because it plainly isn't, in the sense that it doesn't deal with 112.2, it did make a change, and one would expect to find that. And in our respectful submission as well, given that this operation of 112.2 is in such a specific, and if I can put it this way, niche area, then although familiar company law language is used, taken from the context of making calls on contributories, it is here doing something different, because 112.1 has dealt with contributors. 112.2 doesn't just complete or give more powers in relation to liquidations generally. It goes straight into a subset of liquidations, namely solvent liquidations of funds. And then it looks at the rectification of the register of members, and thereby, i.e., as a consequence of that rectification, the adjustment of the rights of the members as between themselves. And that's in a quite distinct context from calls. And of course, rectification itself doesn't invariably require the adjustment of rights of members amongst themselves, because when one looks at section 46, it doesn't talk about the adjustments of members among themselves. It may have that effect, or it may not. If one is adjusting the number of shares, it will have that effect. If one is simply replacing one shareholder with another, it won't. So in our respectful submission, if I can put it this way, the over-conservative adoption of meanings of words in older statutes in different contexts is not, in our respectful submission, the test for how one is to interpret the language in 112.2. In particular, when one looks at Order 12, Rule 2, and your Lordship and your Ladyships have my points in relation to that, and my points in relation to the policy. If one just asks oneself that set of questions as to what 112.2 is doing. The US authority we were taken to is, again, interesting, but it's not dealing with 112.2. And so although it may be tempting to look at other jurisdictions and then find something heterodox in the piece of legislation which we're looking at, in our respectful submission, that's not of assistance when one is focusing on 112.2. The point was made that it would be in certain cases, it would be very hard to work out when the power to rectify should be used. That the fraud was a very small part of the overall valuation of the NAV. At what point would the line be drawn? Well, with Order 12, Rule 2, one may have that problem. One may have a problem which is not binding because of NAV, because of fraud, but that fraud may not go to the totality of the valuation. So Order 12, Rule 2 raises those problems. But of course, with Sub-Rule 5, it enables a liquidator, if it's not cost-effective, to devise a fair and equitable rectification of the register as between the members. Well, so with 112.2, a power is given to the liquidator, but it doesn't give him the ability to decide things on a whim or capriciously. He acts under the supervision of the court. And clearly there is, or there may be, questions of materiality of a fraud in any situation which the liquidator is having to deal with. But that was a situation which was considered by this committee in the Weavering case. And it might just be instructive to see how how that was dealt with. It's at page 3270, so that's volume 12, 61. Now, of course, what we're dealing with in Weavering is an internal fraud, so that's...
Sorry, I think I got the page number wrong.
Oh, 3284.
Thank you so much.
Paragraph 29, Sir Donald draws attention to the fact that the extent of any fraud lying behind the statement of a NAV may vary enormously. He raises the question of the consequences where a NAV has been influenced by a small or minimal fraud on the part of the employee who'd misstated some part of the company's assets. It is, in the board's view, unnecessary to address this possibility, which doesn't arise in the present case, whereas he accepts there was undoubtedly a massive fraud. But in our respectful submission, there is here a massive fraud, and it's not in our respectful submission necessary to answer the question raised, but I should, for completeness, take your ladyships and your lordships to paragraph 138. Which is in the minority judgment of Sir Donald Deeney, with whom Lord Wilson agreed. And this is the point which I think is being referred to in paragraph 29, that the extent of any fraud lying behind the statement of a NAV might vary enormously. And at the end, it would be quite wrong that a marginal factor should render all transactions based on that NAV or ab initio. It's clear when a statute gives an officer of court a power, then there is a margin of appreciation within which that power is going to be exercised. Here, that margin of appreciation is subject to the oversight of the court. And in our respectful submission, that point made on behalf of Primeo is not one which is which in any way derogates from the construction which the additional liquidator places on the section. Those are the points on which I was going to address your ladyships and your lordships in reply. If there are any other points I can assist with, I will be happy to do so.
Thank you very much indeed.
Thank you.
I should say we do have a print of the 2018 Companies Law, if that would be helpful. If you want it, or we can submit it with the note in due course.
Well, Mr. Tregear, you're going to submit an...
We're going to do a note, I think, setting out where 112.2 fits into the context overall of liquidations under Cayman Islands Companies Law.
How quickly can you do that?
We'll try to do that by tomorrow.
Very good.
But the only caveat is we will then obviously show that to the other side to make sure they're content with its contents.
Well, quite. But shall we say, without fixing a firm deadline, within 1 week we will have your note and, if any, the reply from Mr. Smith?
Try and agree it.
No, I think...
Even better.
Yes. No, the objective is we will try to agree a note before it comes to your ladyships and your lordships.
First rate.
It may be helpful to have the Companies Law with that note so one package is delivered, or if the Companies Law is here, it may be convenient to hand it over. I'm very much in the court's hands, so as far as that is concerned.
Thank you very much indeed. We're very indebted to Council for the lucidity and relative economy of their presentations. This is a case in which, quite clearly, a great deal of background work was undertaken, so we express our gratitude also to those who worked and perhaps didn't play a speaking part, shall I put it that way. A very interesting case. The board will take time to consider what advice they will humbly tender to Her Majesty, and the court is now adjourned.